My name is Brissenden from Trinity Chambers, and myself and my pupil Jack Cottrell are going to guide you through best practice in private law fact-finding hearings and schedules in this first webinar. During the coronavirus lockdown, obviously all of us are together at home a lot more. Predictably, there's been a surge in the number of reported cases of domestic abuse. Undoubtedly, this is going to lead on to us as legal professionals having to deal with many more cases involving domestic abuse in the very near future. So consequently, the better we are at drafting Scott schedules, the better outcomes we're going to get for our clients. In this first webinar, I'm going to answer some questions from Jack about fact-finding hearings, about Scott schedules and best practice. In the second webinar, which is going to be live and interactive, we're going to look together at some specific allegations and choose which ones we think should go to a Scott schedule and which ones we should leave out. Now, just a quick note on this. In this webinar and in the next one, we're going to be referring to the person making the allegations as the mother and the alleged perpetrator as the father. Obviously, this isn't always the case, but for the purpose of these webinars, it's going to be much easier than trying to say him, her, or she, he. So I hope that's all right with you. So Jack's got some questions for me, and I'll try and answer them as best I can.
So Claire, I guess we better start at the very beginning, and for the benefit of those who don't already know, what is a fact-finding hearing?
Well, it's usually a hearing that's held separately, but sometimes it can be held within a composite final hearing to try and establish the truth of allegations made by one or both parties.
And why do we have a fact-finding hearing?
Well, primarily it's to try and prove that something happened which one party asserts may affect whether the other party has contact with that child. It's also sometimes where one party wants to show that something didn't happen and the other party's making it up deliberately to try and prevent contact taking place. That's often the case where you have cross allegations. Often CAFCAS will want to have a factual basis or a factual matrix on which they can do a Section 7 report, and they will want allegations to be tested out. Sometimes allegations will keep occurring that don't go away, and the only way to really put them to bed is by having a fact-finding hearing. There's also a situation where one party may want the other to go on a domestic abuse perpetrators program, or they may want them to seek help with alcohol or drugs. And in order to do that, they need to have findings made against them. Similarly, you'll find that where judges are looking at PD 12J, the practice direction regarding domestic abuse, they want to know that all these allegations have been looked at properly, forensically by the court before they can make a safe recommendation for contact with that child.
You've described a fairly wide range of things that can be achieved at a fact-finding hearing. But what sort of things are we not there to do?
Well, we're not there to show that the mum is a good mother or that the father is a good father or not a very nice man. You're there to look at safeguarding concerns, which means it's not also to determine welfare considerations. Clients can get confused and think that this is about a child's welfare. It's only about safeguarding the issues that would then allow CAFCAS to make recommendations for contact.
Mm-hmm. And the key document in fact-finding hearings is, of course, the Scott schedule. Now, for the benefit of those who haven't come across one of those before, what are they and what's the point of them?
Well, a Scott schedule is essentially a table that sets out the findings that the respondent is asking the court to make, and often the applicant's response to each of them. The purpose is to identify the key facts that are disputed, narrow the issues, and to help the parties in the court determine which evidence needs to be gathered. It's also a handy reference tool for the judge and the advocates actually in the hearing itself.
And how do you select the best allegations to put into a Scott schedule?
Well, I do have my criteria, but first of all, I just want to clarify that in no way am I seeking to minimise any form of domestic abuse. What I'm trying to show is that some allegations are less easy to prove, some are less significant as a factor in respect of PD 12J, some are more significant. You need to be able to select the ones that have the best chance of being found proved. So my criteria is the worst allegations, the most recent allegations, the most specific allegations, and the ones that have corroborative evidence. I'd also tend to put at the end of that a final cross-check. So if you can add the words, and so he shouldn't see his kids at the end of each allegation, if it sounds ridiculous, maybe you want to consider removing that as an allegation.
And when you first, I guess, get a client into the office and you're likely to get the whole history of their relationship, and they may give any number of allegations, how many allegations should you be looking to include in the Scott schedule?
Well, firstly, whatever is in the order. So if the order from the judge says that they must be limited to 8 allegations, don't be tempted to put in 9 or 19 or 39 on the basis that counsel can then just pare it down at a pre-hearing review, or that you expect the judge is going to reduce them anyway, so you'll put in lots, expecting half of them to be taken out. You need to choose a limited number that best exemplify the behaviours that you say would impact on contact, using the criteria that we've already discussed. So don't dilute stronger allegations by putting in weaker ones. The impression it's going to give is that you're clutching at straws.
And in terms of formatting, how should you be looking to set out the Scott schedule?
Well, you need to always cross-reference each allegation in the schedule to the statement page and the paragraph, as well as to any additional corroborative evidence you've got, such as police disclosure or other witness statements. You also must ensure that the allegations are numbered in chronological order. It really annoys judges when they jump around in time.
And how detailed should each allegation be, given that you're going to have the witness statement in support?
Well, in the schedule, you really need to put the basic relevant facts that you want to find proven, and you need to ensure that the schedule says exactly the same as the statement. So if the statement says that he threw her down on the floor, don't put in the statement that he pushed her down.
And when you're describing these sorts of incidents, obviously you're wanting to put your client's case as best you can in order to get the allegations proved. Is it a good idea to make the allegations sound as bad as they possibly can?
No, it isn't. Don't put in words or phrases that exaggerate the client's evidence. You've got to be realistic and accurate about what happened. I've heard judges criticise the drafting of statements and schedules when the client then in oral evidence explained that the incident wasn't as bad as described in her written evidence.
And how detailed should the statement be?
Well, details do really matter. It's important that the statement sets out everything in as much detail as it can. If the client, for example, couldn't get up off the floor after an assault because her skirt was too tight, then say so. Or if he hit her across the left side of the cheek with the palm of his right hand, say so. Or if something happened in the morning as they were getting the kids ready for school, or if it was raining, or if he wore a red t-shirt, say this. It's really important that you work on the basis that the only evidence in chief is going to be their written evidence. Don't expect that the judge will let them give any additional oral evidence in chief, only in cross-examination. So you've got to ask yourself, is it going to be enough to prove the allegation on the balance of probabilities without anything further?
And we've talked a lot about how to approach these hearings from the perspective of the party who's making the allegations. But what about if you're representing the alleged perpetrator? How much detail should you be looking to give when you're responding to each allegation?
Well, the same advice applies. Don't just simply say that it's denied or that he doesn't agree with the statement on behalf of the mother. You need to say what did happen in as much detail as possible, unless, of course, he says that she simply made it all up, in which case then consider filing a cross schedule of allegations against the mother. If your case is that she's deliberately inventing allegations to prevent him having contact with the children, well, then say so. I've had cases where judges have in fact found very few of the mother's allegations proved, and then found most of the father's cross allegations proved, including that she has exaggerated or fabricated allegations to frustrate his contact.
And what about the situation where you have other witness statements, say, for example, from family members or from friends who are able to corroborate your client's side of the story? What should you be including in those witness statements?
Well, don't simply just duplicate the exact words that your client has used in the statements of their witnesses. They may have seen or witnessed the same event, but undoubtedly they're going to have a different perspective and a different description of it. You need to use the exact words and the events that they describe, not just what you want them to say because it fits your client's evidence or the Scott schedule. When they give oral evidence, they're going to say it how they saw it. And if they simply repeat word for word what your client has said, it's going to look staged and artificial.
Mm. So going back to what allegations to include in the Scott schedule, what do you do about allegations where the client maybe believes something to be the case, but there's no real evidence to support that? Should you include these sorts of allegations?
Don't make allegations that are difficult to prove, such as that she believed father would have done something if he hadn't been prevented from doing so. It's difficult to prove an intent or a belief that someone would have acted in a certain way. So, for example, that he intended to throw down the stairs but was prevented from doing so by the doorbell ringing.
So obviously you're not always going to have the benefit of having family members or friends witness what's going on. What other sorts of corroborative evidence are out there that you might be able to obtain?
Well, you need to make sure that you have all the corroborative evidence that's available. So get police disclosure at an early stage, get medical records if they're going to describe injuries or a history of abuse. If the child has told the school about something, get a letter from the teacher. Get as much as you can, and then you can decide if it's helpful and relevant.
And what about Marek reports or reports from domestic abuse charities that the mother might have been working with? Are they useful to obtain?
Well, I would say that self-serving corroborative evidence is generally useless because just after a separation or maybe after a father filed his application, the mother told a domestic abuse worker or a GP or 100 other people what she'd experienced. It doesn't prove that it's true. Good corroborative evidence is contemporaneous, it's independently verified, such as the police noting that she had reddening to her face when they attended at the property, or a health visitor recording that mother disclosed to her she was in a controlling relationship, but was too frightened to leave as the baby was so young. That's the best kind of corroborative evidence that you can get.
And another thing we come across a lot are arguments that on the face of it maybe seem a bit two-sided. Should they go in the Scott schedule?
It's important to clarify that arguments are not abuse. Most couples argue. Some arguments become heated. However, it doesn't automatically mean that one party is abusing the other. It only becomes abuse when one of them has an unfair advantage or uses behaviour that's disproportionate to the situation, such as pushing or repeatedly shouting down their partner, not allowing them to speak, or they use psychological abuse, such as gaslighting. That's different from a normal argument.
So you have that situation where one party's maybe reacted in a disproportionate manner, but nonetheless your client admits that she behaved badly too. Should that be left out of the Scott schedule?
No, I'd say it's important to not make out your client to be a saint. It's usually unrealistic and unlikely that during arguments and incidents that the client did nothing wrong at all. Of course, it doesn't justify any abusive behaviours towards them. It may give some helpful context to it. If you attempt to paint the client as having done or said nothing wrong, or that may have triggered or worsened a situation, such as preventing their ex from leaving the room or confronting them about an affair, it simply won't be believed by the judge and their credibility may be brought into question. It's far better to accept that their own behaviour may have also left something to be desired, but that it didn't warrant the behaviour that followed, than to pretend it was all one-sided. The same applies to responses to allegations. Make admissions where necessary, hold your client's hands up to having behaved in a less than perfect way, but then do clarify the distinction between arguments and abuse.
And we focused a lot on incidents that occur between the parties, but what about incidents that involve the children? Is it important to set out allegations including them in the Scott schedule?
Well, this may sound obvious, but if there are allegations concerning a child, include them. In two recent cases I've had to apply to adjourn the fact-finding hearings because the clients then asked me why the allegations about the kids weren't in the schedule and why weren't they being tested. Allegations concerning children may be even more relevant than allegations concerning the client, because if he's behaved in an abusive way towards the children, that may then continue if he has contact with them.
So we've set out our allegations, we pared them down using the criteria that you suggested, and we've worked out what corroborative evidence we need and what we can obtain. What's the final thing to do?
Well, it's important that the client reads both the statement and the schedule carefully before it's filed and corrects anything that isn't accurate and adds to anything that you might have missed. It's much better to do this at an early stage than on the morning of court in the witness box when the client's under oath.
And what if at the end of all of that, you're still not sure whether you should put an allegation in or leave it out?
Well, if in doubt that the schedule's strong enough or you've got questions about it, I'd consider having a conference with counsel and the client at an early stage or before you file it, just to ensure that everything is as strong as it can be, or even email it to counsel to check through. It's important that you get the strongest schedule with the strongest allegations rather than try and correct one at a later stage.
Well, thank you, Claire. I think that's all of the questions I have for you. I found that very useful, and I hope everyone else at home did as well.
In the next one, what we're going to be doing is going through some actual scenarios, some allegations that are going to be sent to you. And together we're going to try and work out if we can all agree on 10 allegations that you would put in the Scott schedule. So that's it for this webinar. We'll see you at the next one. Such as that she believed father would have done something if he hadn't been prevented from doing so. Sorry.
Start that one again.
But was prevented from doing so by the doorbell ringing.
Mm-hmm.
Or the dog barking.
Or the dog barking, indeed. Right. So you're not always going to have the benefit of having family members or friends who witness what's going on. What corroborative evidence might there be that you can obtain? Oh, sorry, let me start again. Just lost the conversational train.
Followed, than to prevent that it was all once. Sorry. Prevent, pretend. They're too similar. Start that again.
Start that one again.